Hello, in this video I'm going to talk a bit about a case that's received quite a lot of publicity this week, and indeed back in April and May when the case was originally decided. This is the case of Lavinia Woodward, an Oxford University medical student who pleaded guilty back in April for unlawful wounding, contrary of course to section 20 of the Offences Against the Person Act 1861. This week, in fact on Monday this week, the judge in the case, His Honour Judge Ian Pringle, sentenced her to 10 months imprisonment, suspending that sentence for 18 months. Now, to start by giving you some definitions and some terms, a suspended sentence, to be clear, is an option that judges have open to them when imposing a custodial sentence of between 14 days and 2 years in the Crown Court. The court may choose to so-called suspend such a sentence for up to 2 years, meaning that the person involved doesn't actually have to go to prison, but is essentially given a chance to turn their life around, to stay out of trouble, and to comply with up to 12 requirements set by the court. Such requirements can include doing unpaid work, being subject to a curfew, being subject to a rehabilitation activity requirement, or indeed undertaking a treatment or programme for alcohol or drug dependency. It's not been made specifically clear, actually, what requirements, if any, were placed on Woodward, but presumably they do include carrying on with her drugs and alcohol rehabilitation programmes, which I will come to talk about a little bit more in a moment. Now, this case caused a lot of controversy in May, when the judge decided to essentially defer sentencing of the case to September, to about now, in order to allow Woodward essentially to continue engaging in rehabilitation programs. She had, since the conviction the month before, started engaging apparently quite seriously in alcohol and drug dependency rehabilitation, counselling, and essentially the judge that is, wanted to give her time to demonstrate shall we say, a longer term commitment to this before he decided on what the eventual sentence was going to be. He said, quote, it would give her a chance to truly rid herself of her alcohol and Class A drug addiction. Now, in particular, at the time, what earned the judge in the case quite a lot of negative media attention was that, at least as some have seen it, he seemed to hint that he would not be passing a custodial sentence, and that he was mindful in this and perhaps influenced in this by the so-called future potential of this young woman, being an Oxford University student and being a potential future heart surgeon. Now again, some have responded by saying these comments were taken out of context, and there's a lot of debate back and forth going on as to what exactly he meant by this. But certainly in some areas of the press, this was reported as essentially indicating that the judge was prepared to give Woodward a favourable treatment, or indeed even biased treatment, on grounds of her being well educated, of her being middle class, and essentially arguing that the judge was being biased in favour of such people and showing undue leniency to such people. What I thought I'd do here is explain a little about how judges are required, and how the judge in this case was required to approach the sentencing exercise in this case, and how they're required to, if you like, weigh up mitigating and aggravating factors when deciding what the ultimate outcome will be, referring as I do so to the specific sentencing remarks which have been published by the judge this week. Before I get to the law, though, I'll take a little bit of time to go through the case itself and what actually happened with this crime. And again, this is largely taken from the judge's sentencing remarks and his summary of what occurred. So, essentially, as I say, Woodward was Oxford, or is indeed still an Oxford University medical student, who had started a relationship in October 2016 with a boy who was a student at Cambridge University. They met via Tinder, which seems to be relevant to some reporting agencies, parts of the media. Nevertheless, what happened is that she went to visit her partner, her boyfriend, at his college at Cambridge University. Now, an important background here is that in a previous relationship, one of her previous boyfriend had got her heavily into the abuse of alcohol and had introduced her and got her very heavily dependent, it seems, or we're told in the case, on Class A drugs. So it's clear that, and most people seem to agree, that at this point she had quite considerable drug and alcohol problems. She's described in the case as an addict, a continuing addict with many problems at the time of the offence. So what happened is, as I say, Woodward went to visit her boyfriend, the victim, if you like, in the case, at Cambridge. And when she got there, he was apparently quite concerned from the outset that evening that she was already heavily intoxicated with alcohol. And what he tried to do was, during the course of the evening, convince her not to drink any more booze. But she kind of didn't seem too happy about that, and at one point the boyfriend got so concerned about it that he decided to Skype her parents to try and get them to intervene. Now, it was at that point that apparently Woodward became very upset that he'd gone and sort of spoken to her parents, to the extent, and she was acting in a way, but to the extent that at this point the boyfriend rang 999 to try and get the police, or possibly the ambulance. It's not entirely clear, involved. It was at that point, after it seems, and we know this from the record of the 999 call, but after he'd rung 999, it was at this point that Woodward picked up a bread knife that happened to be in the residence with them, and essentially stabbed her boyfriend in the lower leg with it. As part of the incident, he also received a couple of cuts on 2 of his fingers. He struggled to restrain her, and indeed to disarm her, particularly after she'd stabbed him and after she'd cut him. It seemed that she was going to start turning the knife on herself. I think it is relevant to note, by the way, that he did restrain her and he did disarm her after he'd received his injuries, which became the subject of the case. Essentially, to cut a long story short, the police then arrived, Woodward was taken to the police station, and the criminal justice system essentially swung into action. Okay, so the case went to trial, or at least it went to court, and Woodward pleaded guilty. She pleaded guilty to the offence, as I say, of unlawful wounding, which is a crime under Section 20 of the Offences Against the Person Act 1861. That plea was in March this year. Now, what happened then is the judge sent the case off for experts to compile what is known as a pre-sentence report. This is a very common thing to do. Rather than sentencing immediately, as you sometimes see on television, what actually happens usually in anything like a complex case or a serious case is a judge will send the case away to have a report written, and that report is usually written by probation officers with the help of other experts, sometimes doctors, in order to get basically a thorough understanding of the defendant, perhaps a little bit more understanding as to why they've committed the crime that they've committed, and that report then is used to give the judge more information on which to base their sentence. So the judge sent off for the pre-sentence report. Now, what happened at that point is that in May, sort of the following month, the pre-sentence report came back, and it's at this point that the judge decided, rather than sentencing at that point straight away, even with the pre-sentence report, he would send the case off until September, so properly deferring the sentence until September. Because, as I said earlier, he wanted, by this point, Woodward had apparently heavily engaged in alcohol and drug rehabilitation programs, and he wanted to see how those programs played out and whether she stuck to them, essentially, and whether they made any difference, before he then decided which sentence was most appropriate. So that took us to Monday of this week, the 25th of September, and it's at that point that the judge and the case reconvened, and the judge actually sentenced Woodward. Now, as I say, sentencing occurred on Monday, and what has happened actually is the judge has published some sentencing remarks in order to allow the public to better understand the process he went through in order to come to the sentence. This is not a completely standard practice. It is standard, indeed required, that judges give reasons for their sentences, but you don't often see in a Crown Court case or in a relatively simple Crown Court case detailed judgments being published in every detailed sentencing remarks being published in every case. It's no doubt that the judge chose to do so in this case because of the controversy that he has been the subject of and the case has been the subject of. So clearly, and there's a very clear sense in these sentencing remarks that the judge is trying to make it very clear that he has stuck to the guidelines that judges need to stick to, which I'll talk about in a second, when they're sentencing these kind of cases. So to try and make it transparent, in other words. Now, in order to understand the modern sentencing practices of judges, it's really vital to know that there is a statutory body called the Sentencing Council. It was created under the Coroners and Justice Act of 2009 and actually replaced a couple of pre-existing organisations that did similar, that concerned themselves with similar matters. The council is made up of judges and also other experts and representatives of the criminal justice system. There is a chief police officer there is a magistrate there is a probation officer there, several people. You can actually see the full list of people who are on the sentencing council at the website I'll put on the screen now. And their role is essentially to develop procedures and to develop guidance for judges in order for them to follow them and really increase the consistency of sentencing. That's really the main goal. There was a concern, and has been for quite a lot of history in England and Wales, that sentencing is not always as consistent as it should be, and so bodies like the Sentencing Council and its sort of precursors were designed to basically try and bring judges into line. De facto, although there is some theory against this, but de facto judges pretty much have to follow the Sentencing Council guidelines now. If such guidelines have been published by the council, then judges must follow them really whenever they're undertaking any sentencing. And so was the case here that Judge Pringle in this particular case followed the Sentencing Council's guidelines on the sentencing of cases of unlawful wounding. Again, the goal being to leave it less the preserve of individual judges and to increase consistency across the board, so that somebody sentenced in Lincoln would be sentenced exactly the same way if they appeared in a court in London, for example. Okay, now I'll put the link to the full guidelines that the judge has to follow on this crime when sentencing on the screen, and also in the description below. It's actually very simple to follow. It's not a complicated set of language to follow, and so on. And indeed the sentencing remarks of the judge very much take us through those guidelines and how the judge has applied them. Okay, so under those guidelines, the very first step a judge has to take is to classify the crime in question into one of three categories. Category 1 attracts the highest sentence, Category 2 attracts a slightly lesser sentence, and Category 3 essentially attracts the lower sentence. Now, in order to decide which category an offence or a particular example of an offence falls into, the judge is asked to weigh up two different issues. One of them is the amount of harm caused by the crime, and the other is the culpability of the defendant for the crime. In other words, how blameworthy the defendant is for committing the crime. Now, they're not left to make this decision all on their own. What effectively the guidelines then do is give a huge list of mitigating and aggravating factors which both increase or decrease the harm objectively, or at least it says objectively, and other factors which could increase or decrease how culpable the defendant is. So, for example, it says under factors indicating higher culpability, a significant degree of premeditation, use of a weapon, intention to commit more serious harm than actually happened, leading a role in a group or a gang. So all of these factors would make the culpability of a defendant higher, and therefore would have an impact on what category the offence fell into. And then in terms of harm, it says things like, well, if there is an injury, then that indicates greater harm. If there's sustained or repeated assault on the same victim, then that would indicate a greater level of harm. And so the judge has looked at all of these set guidelines and all of these set criteria. And the first thing he does is determine that, looking at these criteria, actually he feels that this is an example of what the guidelines call lesser harm. In other words, a lower level of harm has been caused to the victim than is seen in other cases of unlawful wounding. Now, in order to understand that, we should probably look at how the wounds have been described, and again, this is how they are described in the case. Fortunately, the wounds that your partner received were relatively minor. The 2 1 centimetre cut to the fingers were treated at the scene with steri-strips, that's these, and the cut to the leg was closed with 3 stitches. So that is a description of the injuries sustained. And for this judge, for Judge Pringle, it's clear that, and he says in his sentencing remarks, that this is an injury which is less serious in the context of the offence as a whole. And injuries which are less serious in the context of the offence as a whole is a specific description which you find within the guidelines. So he's classified essentially the harm that has been caused as relatively lesser harm because in his view the injuries are not that serious relative to, certainly to other examples of this kind of crime. So moving on, he then goes on to culpability. And he says, actually, there is a couple of factors listed within the Sentencing Council guidelines which apply here, and consequently, he deems the defendant Woodward, the offender at this point, Woodward, to be highly culpable for the offence. So not just a low level of culpability, but a high level of culpability. This is essentially because one of the factors which the sentencing guidelines say means that an offender is highly culpable is if they used a weapon. And she did use a weapon in this case. So in a sense, under the guidelines, she automatically counts as highly culpable for this. So to recap then, what the judge determined is that on the one hand, the injury, the harm caused was a lesser level of harm. But on the other hand, the level of culpability of Woodward for the offence was high. So low harm, high culpability. Under the guidelines, it specifically says that if you've got a case of low harm, high culpability, then that counts as a Category 2 example of the offence. In other words, the middle one, not the most serious, but not the least serious. The guidelines then specifically get into sentencing and length of time, and it says that when sentencing for a Category 2 unlawful wounding, the judge should, as a starting point, begin thinking about the sentence in terms of 1 year and 6 months custody. It then says, and it puts limits on the judge's discretion, the judge can go up to 3 years custody for this, or can go back down to 1 year custody. So they should start thinking 1 year, 6 months is the correct sentence, but they could go down, or they could go to 1 year, or up to 3 years, and that actually all depends on the presence of mitigating or aggravating factors. And that is exactly actually what the judge next does, and what the judge is actually required to do in the next part of the Sentencing Council guidelines. Now on this point, the judge notes that the guidelines list being under the influence of alcohol as an aggravating factor. So being drunk whilst committing the crime is an aggravating factor. He says, whilst that in part was a result of, He says that the reason that whilst being under the influence of alcohol was in part the result of a previous and highly damaging relationship, you were old enough and intelligent enough to realise that overindulgence would severely affect your behaviour. So he's basically saying there's no excuse. You were drunk, you were kind of led to drink and led to drug and drink abuse by a previous partner, but that's no excuse because you're old enough to know better and to know it could have an effect on you. So there is an aggravating factor here. But next, the judge moves on to discuss mitigating factors. And it's in this determination where I suspect most of the controversy has been sown, really, because he remarks in the sentencing guideline, in the sentencing statement, that there are in fact many mitigating features in your case. So for him, there are many mitigating features to, in other words, reduce the sentence. Now he then goes on to list all the mitigating factors which he sees in the case and which the sentencing guidelines list as mitigating, as it were, the sentence in the case. And there are essentially 4 of them. And again, these are all specifically listed as mitigating factors in the sentencing guidelines, sentencing counsel's guidelines. So the first mitigating is that she had no previous convictions, none at all. It's quite unusual actually for someone to offend first time with a relatively serious offence like Section 20, unlawful wounding, but she had literally no convictions on her record. The second mitigation is that she showed remorse, which the judge felt to be genuine. Again, remorse is listed as a specific mitigating factor in the guidelines. 3, her lack of maturity. The guidelines say essentially that relative to age, if someone seems particularly immature, that is in fact a mitigating factor. So again, following that, a mitigating factor because the judge felt that that was the case here. Then number 4, the judge points to reports from the experts that he's spoken to and has heard evidence from that make it clear to him that from an that Woodward suffered from an emotionally unstable personality disorder, possibly a severe eating disorder, and alcohol and drug dependency. And essentially, these kind of medical problems or diagnosed medical problems and dependencies are listed as mitigating factors, again, under the Sentencing Council guidelines. Then finally, the judge gets to what he says specifically is the most important mitigating factor which applies directly to Woodward, and that is essentially her commitment to drug and alcohol rehabilitation, which she has demonstrated through consistently going to the programmes in the intervening period since she was convicted. Again, a determination or demonstration of steps taken to address addiction or offending behaviour is a specific mitigating factor listed in the Sentencing Council's guidelines. So these are the key issues, essentially, that determined the sentence. The guidelines go on to say as well, it should be said, that a court must also take into account an early or indeed a guilty plea, as was the case here. You know, the offender, Woodward, did of course plead guilty straight away, negating the necessity for a long, complicated and and certainly very expensive trial. The requirement to give a lower sentence as a result of an early guilty plea is found under other legislation, in fact section 144 of the Criminal Justice Act 2003. So, in many ways then, the judge is presenting this as very much having followed the specific guidelines that he must follow under the Sentencing Council, and also the relevant legislation. It's interesting actually that unlike perhaps, or what some people say, he said back when she was convicted and at the first sort of sentencing hearing a month later, when he started to imply, or apparently started to imply, you know, taking into account her education, he's very careful not to say anything about, you know, her potential as a future doctor or her education or her you know, self-worth, as it were, as relevant to the exercise. And indeed, that is quite proper, because those kind of factors do not appear as either aggravating or mitigating factors that the judge is permitted to consider under the Sentencing Council's guidelines. Again, he very, very much sticks to the letter of the guidelines in his sentencing remarks. So there you have it, really. I mean, it is certainly, you know, an interesting case, probably more interesting perhaps, to be honest, for the reaction and the concern that it's raised than possibly the offence itself, which in many ways is not an unusual kind of case. There are, of course, arguments going back and forth. You know, some newspapers labelled this as posh or toff's justice, because for some there is still this lingering perception that Woodward has received a lenient sentence as a result of you know, alleged special status, education, potential, and all that. Certainly, if the judge did indeed imply those kind of things, and he says he didn't, he says it's been taken out of context. If he did, then he was probably a little bit undisciplined, shall we say, to sort of, you know, imply that kind of thing. And again, he's been much more disciplined, I think, in the remarks this week to make sure he's not implying that kind of thing. But you know, the concern that the criminal justice system treats different people differently, or different kinds of people, or different people with different backgrounds differently, is a perennial problem, and it's not one that should be just ignored or thrown away. You know, as well as the class issue, there is of course the continuing issues about the criminal justice system treating people, or apparently treating people from ethnic minorities differently to how they treat people from ethnic majorities. There was a long-term discussion about the differences women and men experience in the criminal justice system. Which goes both ways in many ways. I mean, there are those, at least a couple of people I've noticed have commented that, you know, this being a case of domestic violence, you know, there might, it has been questioned whether had the victim been the abuser in this case, whether or not there would have been such a lenient sentence. What I do know, and what we can be sure, is that the same sentencing council guidelines would have applied, and so the judge would have had to apply them just as he seems to have applied them here. Again, I suppose the irony to this is that the guidelines that the judge has followed were very much intended to sort of reduce the risk of inconsistency between sentence and reduce the risk that a judge might be minded to sort of help out particular kinds of people. And so I suppose what this shows us, it shows us a couple of things. One, this importance that, you know, people need to feel that justice has been done fairly, and, you know, almost the impression of justice is almost as important as the technicality of it. And yes, perhaps the lingering concern that, you know, we still haven't quite got it right in all cases. Again, these are debates to carry on having, and we'll certainly be having more of them, certainly as cases come out in the near and distant future. Okay, so I will leave it there, and I hope that was in some way useful to you. Bye-bye.